Check, check. 1, 2. You should be hearing it now. I had the aux down. Yeah. Check, check. 1, 2, 3, 4. Yeah, I brought it down over here. Too loud? Okay, hold on, Josh. Okay, so the music. Let me know if it's on too high. I'm gonna set it again. Okay.
Good morning, comrade.
Hey. Right about there. Okay. Okay. Check, check. This is the handheld, and this is the music going on at the same time. Check, check. This is the other handheld. Check, check. Testing the other handheld. 1, 2, 3, 4. Good level. Okay. Check, check. Testing lavalier. Mic check. 1, 2, 3, 4. Check, check. Testing 1, 2. Got it? Okay. Is it? Okay. Check. Testing 1, 2, 3, 4. Hey, hey. And then I'm gonna have Wiley go over to the podium. Hey, Wiley, can you go over to the podiums and say a few words? Check, check. Testing 1, 2, 3, 4. Checking 1, 2. Turn that down. Check, check. Testing 1, 2. That's good. Okay.
Checking this boat. Check 1, 2. I'd like to thank everybody for coming today. I have a lower voice than usual. I can kind of talk a little higher, but it's not a real voice, but you can get the picture. Check 1, 2. Ladies and gentlemen, boys and girls of all ages, welcome to the wonderful world of Wiley. I've invited all you empty chairs here today to speak to me because, frankly, only empty chairs show up to listen to me. Check 1, 2. Mic check 1, 2. I think this one has a southern accent to it. This is a southern mic. This is from the southern hemisphere. Check 1, 2. Ladies and gentlemen, check 1, 2, 3, 4. Please take your seats. The program is about to begin in a couple hours. Check 1, 2. Thank you for coming. And have a good time over there in the Heritage. Time check.
2 2 1 2 2 check 1 2 2 2 1 1 2 2. I don't hear any ringings. It's just yeah, it sounds like me. How much do you have the low pass? What was that? Yeah. Sibilance. 2 2 2 2. Oh, nothing here. Nothing here. Why is this one muted? It's sibilance. 1 2 2 2 1 2. Yep. All right. 1 2 2 2 2. Check 1. Okay. Sounds good. Pretty much. You want me to check the lavaliers up here? Alfredo, here you go. Ready? This is yellow. 1 2 2 2 1 2. There's a ring. Probably lower mid, probably around 400, somewhere between 250 and 600 maybe. 1 2, you can bring it up and you can probably get the feedback. 1 2 2 1 2 2 1 1 1 1 2 2, walking around the stage. 1 2 2. I don't think anyone's going to be going in really proximity to the speakers, but just in case someone sits out here. 2 2 1 2. Good. Okay. Great. 2 2 1 2 2 2 2. Now I'm on white. White. Oh, whoa. 2 2 1 2. Low mids probably. Just testing 1 1 2 2 2 2 1 2. Hey. 2. No, let me walk around. Just testing 1 2 2 2. Testing 1 2. Nope, I'm not hearing it either, really. 2 2 2 1 2. Great. Okay. Do you want me to leave the lavaliers up here or bring them back? Right, because we're going to probably mic them up. Testing, testing, testing.
Oregon, Washington, Idaho, practices as a partner at Holland and Knight, where he primarily advises employers or lawyers on matters of professional responsibility. It's kind of ironic that David's our first speaker because I think of him as sort of the last lawyer I want to call. But here he is to speak to us about matters of professional responsibility, David Elkanich.
Good morning and thank you. I just realized that this table is crooked and there's nothing underneath it. Good morning and thank you all for having me here this morning. It's great to be here. I have to say I'm feeling a little lucky in part because I thought that this presentation started at 8:30. And I thought I was early in coming over here at 8, and so it's great to see so many of you already here. That's great. It just goes to show that it's important to be professional, to be early, to be timely. So we're here today to talk a little bit about money. We're not here to talk about how you practice law to get money. I mean, that's for the rest of the conference. We're going to talk a little bit about how we charge for money, and how we can take steps to collect money. And I think money is a really interesting topic for lawyers to talk about and think about because there's this sort of perception that money, I think, is bad, or that we shouldn't talk about it. We should talk about it with our clients. We shouldn't try to go and get it one way or another. And the problem with money, in part, is that it really reflects a little bit on what we are as lawyers. And just as an example, how many of you, if I asked you right now, could give me a lawyer joke, a joke about lawyers? How many of you? Okay, well, it's probably early. I think you probably all could later after you hang out with John and have a few beers. And of those that raise your hand, how many of those jokes are about money, right? And how lawyers deal with money, right? So, for example, what's the difference between a good lawyer and a bad lawyer? Does anyone know? I'm sure there's a lot of differences, and I can tell you from my practice, I've seen lots of differences. But for this purpose, a bad lawyer unfortunately makes a case last for many years. A good lawyer, however, makes it last even longer. And it's funny because it's all about money and what we do to get money, right? Or there's one where a client, exasperated, runs into a lawyer's office and says, I know you're expensive, and I want to ask you a question. How much do you charge? And the lawyer says, well, I charge $500 to answer 3 questions. And the client says, well, that's an awful lot of money to answer 3 questions. And the lawyer says, yeah, it is. What's your 3rd question? Right? So these exist everywhere. One of my dearest uncles, much older than I am, I saw him a couple years ago, and it was around New Year's Eve. It was back east, and my uncle, and I think he did this from a very loving, good-natured part, would always come up to me because I was cold. I, as you heard, grew up in Arizona, so like even walking over here this morning, I'm like, wow, what happened to the warmth? He'd always keep walking up to me and saying, wow, look, a lawyer with his hands in his own pockets, and it was funny the first 7 times. And then, so these kind of things keep happening. Or just one more, because it's early and I'm trying to keep your attention. There is an elderly, very wealthy man about to die. And he has so much money. He wants to take some with him to the afterlife. And he brings in 3 of his trusted advisors. He brings in his doctor, his priest, and his lawyer. He brings him into a room and he says, okay, I'm going to give each of you $30,000, and I'm going to entrust it with you so that when I die, you walk up to the coffin, and I want you each to put $30,000, put that money in an envelope in the coffin so I can take it with me wherever I'm going next. And they all dutifully agree to do this. This person passes away, the funeral happens, and all 3 come in, and all 3 go up and put an envelope in the coffin. And as they're going away afterwards, the priest breaks down and says, I have a confession to make. I actually only put in $20,000 because I needed $10,000 for repairs to our church. And the doctor says, well, since we're making confessions, I only put in $10,000 because I needed $20,000 for some new equipment in our office. And the lawyer looks at them aghast, right? Knowing his obligations under the rules of professional conduct, the lawyer says, I can't believe you guys did that. I want you to know that I put in an envelope with the full $30,000 made payable via personal check. So what we're going to talk a little bit about today is money, right? We're going to talk a little bit about the ethics rules that go along with money, how we charge fees, how we deal with attorney liens, how we take securities, a little bit about flat fees, attorney liens, garnishments, but there are things that we're not going to be talking about today. So for example, one of the things that we're not going to be talking about is sort of general trust account issues, right? And although we're not, it will come up in some of the things we talk about because trust accounts are important and money goes generally into a trust account, hopefully for all of you, with exceptions. But it's, although I'm not talking about trust accounts, I think I would be remiss if I didn't just remind you how important it is to keep trust accounts and to keep client ledgers and to keep general ledgers to make sure that earned money comes out of trust, not to commingle. You can commingle all you want this weekend, but not with your trust accounts. And when we think about things like abandoned funds, make sure you understand what you do with money that's in trust that's been abandoned by a client or you can't find the client to give them back. So things like that are important. I want you to think about them, but they're not really things we're talking about today. Today we're really going to be talking a little bit about charging and collecting. Okay, so we're talking about money, I think, for lots of reasons. Well, I think we're talking about money because money is so directly related to sort of what we do as lawyers, how we are able to do what we do, but also to our reputation and our professionalism. And I think that practically speaking, it's really important because of the four sort of main issues I put up on the board. One is discipline, right? We want to be aware how we're handling money, how we're seeking it, because if you do it wrong, if you do it in violation of rules, obviously the bar can come knocking. They no longer, well, they usually don't send envelopes anymore. Now you'll get these emails from them. So you don't want that if you don't have to have that. And we'll talk about that throughout today. The second is defendant. It's much better to represent defendants than to become one yourself. So I think that knowing how to manage fee issues will hopefully keep you from becoming one. And one of the things we're going to talk about a little later today is bringing actions against clients and whether you should or shouldn't do so in order to collect fees. Most of you probably have thought this through, I hope, and one of the real risks in doing that is becoming a defendant in sort of a counterclaim for malpractice by the client that you're suing for fees. The other main issue with it, and this is a real issue when a client sues you in a fee dispute, is that fee disputes aren't generally covered by your PLF policy, right? There's an exclusion in your PLF policy for fee disputes. So I have seen in the past plaintiffs' lawyers file an action and frame it. I mean, there's a lot of crafting that can be done with complaints, and sometimes they're crafted so that there is insurance coverage, and sometimes they're crafted so that there isn't. And so it's something to be really mindful of when you're dealing with clients so that you're not on the back end of having to defend a lawsuit for which there might not be any PLF coverage. Of course, if conflicts come up, if issues come up throughout, disqualification is always a possibility. Someone could try a case because of an interest you might have in it or otherwise. Then is really probably the dirtiest of all the words because we're here to talk about how to get money, not how to give it back to somebody. And so disgorgement usually comes up where there's a situation in which you have to refund because of a breach of a fiduciary duty somehow. And we begin 1.5a. And 1.5a is into an agreement, an illegal or clearly excessive fee or a clearly excessive amount for or collect, right? You can be disciplined under RPC 1.5 regardless of what money that is clearly excessive or that's illegal. So long as it is something that is charged, it's on an invoice, if you ask a client to pay it, if it's an agreement that you admissible, those are the types of situations that can be disciplined by 1.5A. Generally, profit centers money on providing legal services to clients. We generally can't mark up costs and pass those on to our client. Clearly excessive, though, I think is always easy, right? I mean, I remember in law school in my contracts class, my professor said, anytime you see the word clearly, it means that something's not clear at all. We did that, right? Because it says clearly. So I feel like it's huge. I ever use it. It's weird that it's in an RPC because it's not what the ABA model. ABA's model rule deals with sort of unreasonable fees. And in 1.5B, it talks about how to define whether or not something is a clearly excessive fee. And it gets you really clear that says that it's clearly excessive if a lawyer of evidence is left with the definite and firm conviction that the fee is in excess of a reasonable fee. And I'm sure that's a standard all of us can regularly apply every day. And then it gives you a bunch of factors to consider to determine whether something's reasonable, including how long you've been practicing, your relationship, how complicated it is, and things like that to determine if something's reasonable or not reasonable. We'll come back to the standard a little bit throughout, but it's really important to remember that when we're charging fees, they need to be reasonable. I like saying it because I think it means something different, or it should, because they're different words, but I think practically that's how the bar views it. First, in RPC 1.5, and talk really quick about flat fees. I know that this group probably uses flat fees, and flat fees earned upon receipt less often than many other groups do. I didn't want to. RPC 1.5C3 specifically allows lawyers to charge. You have read it and studied it before in the past. It came in. I think it was effective like end of 2010. So it's been around for a couple of years now, but the law has always, in Oregon at least, allowed earned upon receipt fees. And an earned upon fee is a fee that you receive that you don't have to put into your trust account. So normally the way advanced deposits work is new client comes in, you say, I'll represent you, but I need $20,000 to put into my trust account, and $20,000 every month, so I make sure I'm getting paid, right? Because if you send the invoice out later, it's often, you may not get money back from the client in response to that. And so what this allows you to do is take that $20,000 and not put it in your trust, automatically put it in your operating or your general account, right? So that it's your money. Or to say something is earned, it's not really non-refundable either, because it can be refundable if you don't actually. And one of those things is that this is your money. Like garnishments, right? Or 15, you have to keep it there until that. By disputing a fee, tell them that money is already in your operating, it removes that leverage from the client. In order to charge one of these fees, you have to have a writing signed by the client, right? Or frankly, in Oregon, in which the fee agreement is here, 1.5C3 for earned upon receipt flat fees. The other is contingency fees. So it's great that I'm starting out with two topics that this group does not use very often. Awesome. And speaking of that, well, you'll get a laugh in just a second, hopefully with me, not at me. But the writing has to be in writing, has to explain that it's going into operating and not your trust account, and has to let them know that they may be entitled to a refund if you don't complete the work. Okay, contingency fees. Can you do contingency fees in family law cases? Does anyone think you can? If so, we'll talk. That's great. It's marketing for me. Generally, you can. And RPC fee in a domestic relations matter, the payment amount upon the securing of a divorce or upon the amount of spousal or child support property settlement. So that means that you cannot take a contingency fee property that could be awarded in dissolution. I think that's probably beaten down into so much, not even a question. least I hope, and I haven't normally a contingent fee for this work. Show of hands, how many think you can do it? Eight is that I don't know if you're awake or you're just not sure, or you're okay. So can I see hands one more time? How many think that you can do this? Okay, just to see if the rest of you are. Okay, so if you look at, there is an ethics opinion that talks about hypotheticals sort of similar to this, it's 2005-13, and the opinion actually says, yes, you can. The fee has to be reasonable, and it has to be one that's already been obtained. So you can't be out obtaining this award for child or spousal support, but it just, an opinion 2005-13 suggested. Ari represents Jenna in a dissolution proceeding and charges a reasonable, i.e. not clearly excessive hourly fee. Jenna asks Ari to represent her in an interim representation on a contingent fee basis. Show hands. If the last one, you're like, well, if the last one was yes, I bet this one's yes too. The opinion says that you can, yeah, it's sort of yes qualified as well. You can take something in a situation like this. Even if the cases are joined for trial, the opinion says that you can generally do it. The opinion makes clear that you need to have separate agreements, though, for both matters. Recommends that you keep separate files, and in particular, you should bill them separately as well, or record your time separately. Besides how important accurate billing records are, both for you and your client, and for me later, if you hire me to represent you in a discipline, accurate billing records are in these situations. Okay, so attorney liens. I'm going to talk a little bit about attorney liens, which I think is all that any of you care about, because those walking in, everyone said, this is the attorney liens presentation, which is great. So we're going to talk a little bit about attorney liens. There are two primary liens that I want to talk about this morning, and then I'm going to separately taking security interest in property that could be the subject of a dissolution. Because I think they're slightly different issues, and I think sometimes we inaccurately use language that conflates them together a little bit. So there's two types of attorney liens by statute. One is what we call a or possessory lien, and the other is what we more so call a charging lien. And the possessory lien is one of those situations where you have a client, you either withdraw from the client on your sort of voluntarily because the client is paying you, or let's say you get and the client owes you money, right? And then goes to a new lawyer. And so you're sitting there with this client, 87-430. It provides for a retaining lien that attaches to all your papers, personal property, and money of the client in the possession of the attorney, and gives you the right to retain it until the fees are fully paid, right? That language is broad, right? We're gonna talk about some limitations on that language in just a second. But what that does is it allows you to have some leverage to get paid after you leave. Second is a charging lien. It gives the attorney a right to be paid from the judgment or any other disposition in the action in which the attorney provided services and becomes effective when the action is commenced. There's a whole series of statutes that apply to that. So I'm going to go to both of them in a little more detail. And I didn't say this at the beginning, but if you have questions, talk about ethics, like to get ethical or academic about things. And it's really great if you can conversation in a particular direction and ask questions. I would remind you, a room of 100, I don't even know how many lawyers are out there, of lawyers, that they're lawyers, but not your lawyers. So please don't reveal too much confidential information in asking questions. Or I'll just assume that it's being asked on behalf of your friend or the person who's still asleep. Yeah.
Flat fee case, if you're returning money to the client, does it stay in general, or do you have to shift the trust?
It's a great question. The question is, in a flat fee case, and you're returning money to the client, do you have to move it into trust? Do you mean before you return it back to the client, or from the general? I think if it's a flat fee earned upon receipt case and you don't complete the matter, so typically in those flat fee earned upon receipt cases where it says the client may be entitled to some amount of money if you withdraw, if you do withdraw, you generally have to, the way the bar likes you to do it is to determine what percentage of time is spent on the case. So if you worked on the case about 75% of the case, then you could keep 75% and return 25% to the lawyer. The bar doesn't like it if you say, well, my hourly rate is $400 an hour, so I spent so much time on this that it would have extinguished the amount of money in there. They don't like that. They want you to look at it from a percentage standpoint. I have a lot of opinions about that, but I'm just gonna tell you what the bar likes. And so what you do at that point, I think it's appropriate to just send it back from your general account and just issue it at that point. One of the things we'll talk about later is, and I mentioned this, that disputed funds have to stay in trust. So if a client objects to an invoice or what you're doing and they dispute the amount of work you performed, generally you have to keep that money in trust. If the money's already been transferred to your general account and the client disputes it, there is not an obligation to put the money back into trust. Okay, so it's another good reason to transfer money once it's earned when the invoices are sent, so that that money's in your general account and not subject to being disputed and stuck in your trust account for an indefinite period of time. Thank you for the question. Does that help? Okay. So the retaining lien statute, which is the file, which is can I hold on to my file in order to get paid, is an automatic lien. It's provided by statute. There's no filing or anything required. You don't have to provide something in court that says I have a lien over these papers or anything like that. Like I said, sort of considering these two situations. So consider a situation in which a lawyer is terminated by a client, sort of on this sort of metaphorical eve of trial and is owed money. And then consider a separate lawyer who withdraws from a representation because they're owed substantial funds from the client, right? After the terminations, after the withdrawals, which are both court approved, which they need to be generally under 1.16C, both clients go and retain other counsel, and in retaining other counsel, they both retain other counsel, they both owe the lawyers money, and both lawyers have these files that the clients at that point want, right? So the question always at that point is, what do these two lawyers get to do, right? Do these lawyers get to keep the files, or do they have to give the files over, right? And, I wouldn't be a good ethics lawyer if I didn't give you both a yes and a no answer, something like this, or like a solid maybe under most circumstances. Do you have to turn over the files? On one hand, no, you don't have to turn over the files. And there's an ethics opinion, 2005-90, which I believe should be in the materials that I provided and that you have. If the client has the means to pay the lawyer but chooses neither to pay it or to post a bond, then the lawyer may hold onto the file until payment is received. Generally, you don't want to prejudice your clients. And so if the client has the money and is not paying you, and the statute allows for a mechanism by which the client can post a bond in order to obtain the file, if they don't want to do that, the opinion says you don't have to give it back. But you do have to give it back if the client is without the means to pay and will be prejudiced without the file. Then the attorney's lien is subordinate to their fiduciary duty to the client, right? So if the client needs it and can't pay, then generally you have to give it back. I think this issue, how much you want to be a defendant in some litigation down the road, or how much you want a bar complaint filed against you because you're not giving the file back, or now I have lawyers tell me all the time, look, I've given them everything throughout the case. I copied them on, I sent them emails, I sent them all the pleadings filed. They're not prejudiced because they essentially have a complete copy of the file. But remember, under the ethics rule or the ethics opinion relating to sort of what constitutes a client file, it's broad. It includes sort of end product stuff like pleadings and letters and emails, but also work product. Stuff you generate is part of the client file under most circumstances. And if you haven't looked at those opinions, it used to be 2005-125, but it was updated last year. I think it's like 2017, one something. It's at the bottom of the list if you go to the table of contents on the ethics opinions. It talks about sort of what a client file is, particularly it's been updated to deal with electronic issues. So I think it's really an issue about managing risk. And if the client has a need for the file and without it, they could be prejudiced, I think that you really risk a lot in not providing the file. Yeah, John.
Can you
That's a great question. The question is, can you bind a client to your definition of a client file? And I haven't seen the issue come up particularly like that in terms of a client, an engagement letter saying, we define our client file to be all end product material and not work product or internal communications or emails or billing information or whatever you want to say. And the ethics opinion doesn't specifically address that. The ethics opinion, though, talks about it very broadly and says that clients generally are entitled to access everything in your file with some exceptions. Particularly, there are exceptions if you, under this line of cases, sort of the Crimson Trace exception is what I think of it as, which is the exception if you consult counsel relating to your ethics obligations or malpractice or something like that. That stuff can come out, or there's all sorts of exceptions in that opinion. But generally speaking, work product and end product materials are both included in the definition of a client file. I think, John, there is a footnote in that new opinion that we make sure to get in there, which is that you and the client can agree. You know, if the client calls you and says, I want a copy of my file, it doesn't mean that you have to pull everything and give it to them right away. Right? You don't, because clients don't really always understand what it means to say, I want a copy of the client file. They might just want pleadings, or they might just want the correspondence. They don't really know that nowadays with our systems, some of us may have 7 drafts of a complaint or all sorts of that internal information and smaller. Outgoing cases, so I think of it work like, please let me know if you need anything else from the client file, so that they're aware that there's other stuff there, but they have to go through because they may not necessarily need all of that, and the time and expense in pulling all of that electronic data and everything else is disproportionate, I feel like, oftentimes to the need that the client has. So I would do it that way if you want to limit it, but it's an interesting idea, yeah. Any other questions about files? Okay, so I really think it's an issue of managing risk, and I'd look at the ethics opinion. I think if the client requires it or needs it or could be prejudiced by not having it, I think you're at real risk in not getting it over, even if you think they're wealthy or they're squirreling away money or they could pay you, but they're just refusing to pay you. Okay, about money you're holding on to. The statute suggests that this possessory retaining lien also applies not just to the file, the paper file you have, but any money you might have in trust, and that you could apply that to monies owed as well. But I would be very careful. We've talked a little bit about funds that are disputed and held in trust, and this would be subject to that. So even though you you possess a retaining lien or a possessory lien, if the client disputes some portion of your fees, even if they go onto a new lawyer, those fees have to remain in trust. It's RPC 1.151E. If only a certain percentage of them are disputed and the rest is either undisputed that you've earned it or undisputed that it's theirs, those funds should be distributed to whoever they're entitled, who's entitled to it, and then those disputed funds should remain in trust. Okay, charging liens. Charging liens are a little bit different, and these are the liens that allow you to file something, to follow a specific procedure so that you can take money from whatever judgment or settlement comes out of a case. And they are different to possessory liens for sure. And this statute provides notice to the world that you have an attorney lien for fees and that arises when an action is commenced. It's interesting to think about the differences between them and how we follow these procedures. And I think one of the biggest differences is this right to enforce it potentially against third parties who ignore your lien. And so if you're really curious to read something interesting this weekend, I know, probably not, at least this, but just in case, if you want to, you should read this Potter versus Schlescher Company case. Some of you may already have. It's a 2003 case. The plaintiff, an attorney can enforce an attorney's lien for fees against a defendant when the plaintiff's client and defendant settled their action without the plaintiff's knowledge and without satisfying the lien. So this was a situation in which, just to sort of get to the underlying facts, which are pretty simple, there was a racial discrimination lawsuit filed by a plaintiff against a defendant. It was filed sometime in 2016. I think it was like December, or no, sorry, not 16, 96, December 96. The lawyer had a contingency fee agreement for 1/3 of the recovery. The case litigates in September of 1997. The plaintiff and the representative of the defendant have a special meeting by themselves without lawyers present and settle the case. And at this point, the defendant says, well, don't you have a lawyer, and are you going to pay your lawyer out of this money I'm giving you? And the fee was something like $12,000, the settlement was something like $12,000. He's like, this is none of your, literally, this is none of your business. Let me deal with my own lawyer and my own attorney fees. And the other side is basically like, okay. And then the lawyer finds out about this settlement and files a lawsuit right afterwards against the defendant who settled that case, saying, hey, you ignored my lien. I have a lien on this. You knew I was on this case. You knew I'm entitled to some type of recovery, and you did this. And he had filed, this lawyer had also filed a notice of lien as well. And so what he said, the plaintiff, what the lawyer argued was, look, this is a lien on an action, and it can be enforced against either party to that underlying case that settles it in contravention of that attorney lien. And the defendant argued, oh, no, it should only apply to proceeds. And so since they were the only one that received the proceeds, he can only sue his own client, he can't sue me. And the court disagreed, and the court allowed the lawyer, it strongly, the Supreme Court came out in strong support of attorney liens on behalf of lawyers, saying that this lawyer had a right to enforce their lien against a third party. Now, the Potter case has been referenced subsequently, and I won't go through all of those cases with you. I think they're still sort of trying to figure out some of the scope of this. But there was one interesting case, I thought, in bankruptcy court a couple years ago. It was a case called In re Williams, Love, O'Leary. And I can't read my writing, but it might be Pearson, let's say, maybe. See me afterwards if you have questions. And in that case, a lawyer sought collection on an attorney lien that the lawyer had filed. But in that case, the lawyer wasn't the one who had a contractual relationship with their client on the case, but was rather sort of a contract lawyer. And the court essentially said, well, since you're not in privity with either of the two parties, you don't get to enforce your attorney lien in this context. And so it was a bankruptcy court case, though. I don't know how the Supreme Court would deal with it, but that's at least one of the more interesting takes on it. There are specific procedures to follow if you want to assert a charging lien and you want to file it. And they're different depending on whether or not it's money at issue or personal property or real estate. And I just direct you to the statutes for some of these. I don't want to get kind of bogged down in sort of the details of a charging lien statute, but just be aware that the requirements are different depending on what you're trying to attach against. There's different recording requirements, notices, and things like that. But there's 2 points that I think are important for lawyers to know. First, charging liens are sort of super powerful, right? Sorry, since I have no idea about time this morning, I'm told I only have 10 minutes left, but I'm going to keep you for about another 40 if that's okay. So charging liens have priority over all other liens. They're like super liens, right? So except for the exception is tax liens and prior liens of record. So this is great, right? They're really powerful liens to enforce. And then second, if you have to foreclose one of these charging liens, you can charge attorney lien fees on it as well to a prevailing party. So that's also good for us. Okay, so I'm going to kind of try to move a little bit faster since I'm running out of time. But real quick, I wanted to talk about, well, first, any questions on attorney liens? Great. Garnishments. So just real quick hypothetical about garnishments. Chris terminates his relationship with attorney Astrid during the course of litigation. Chris then hires attorney Kevin. Chris has an unpaid balance with Astrid for attorney fees. Astrid obtains a judgment against Chris for fees incurred in the course of litigation. In an attempt to collect on the judgment, Astrid caused a garnishment summons to be served on Kevin as garnishee. The summons specifically is custodian of client's retainer unused, although technically it should be advanced deposit, not retainer, but that's okay. Astrid also had served on Kevin a subpoena duce tecum for all documents that disclose the amount of retainer paid to the custodian by client and that disclose all charges against said retainer. So a situation in which a prior lawyer is trying to garnish the trust funds of the subsequent lawyer when the prior lawyer hasn't been paid. Has anyone seen something like this happen? Yeah, pretty common. So is it okay? What do you think? The lawyer do it? We don't. I hope it's we don't know and not just know. But yeah, because we start with this presumption that funds in trust aren't yours, right? Funds held in trust are client funds. They're their money, not your money. It's only your money once it's earned and it's transferred over to your general or your operating account. And it's interesting because some of the language discussing garnishment issues deal with whether this sort of unnecessarily restricts a client's ability to hire new counsel if you are going to just go garnish whatever money they're going to give to that new counsel, and whether it puts them at a significant disadvantage. And the opinions that I've read that have said it sort of say, well, it's kind of their fault that they're in that position, and have said it's okay for a lawyer to do this under these circumstances, to try to garnish that subsequent trust account advance deposit that's being held in trust. But I think it's a lot of questions for the receiving lawyer who gets it to think through, right? I mean, I think the first thing that a receiving lawyer who gets one of these garnishments should do is think, okay, well, how do I respond? Can I disclose that I even have money? And I've got to talk to my client about this right away because I have this obligation under RPC 1.4 to talk to our clients and to communicate with them. And so the client may say, you're right, it's valid, I have no defense to it, just pay it, right? Just give it out, right? A client could say that. And it doesn't matter if it's a prior lawyer who's trying to garnish that or anybody who's trying to garnish your trust account in order to get your client funds. If a client has no frivolous argument against the payment, then it seems like a good idea to just pay it. But the client might have actual legitimate arguments. And maybe the client says, look, they're overcharging me for work they didn't do, or I didn't approve of the work they did, or they churned the file, or whatever the client wants to say, that there's a valid dispute about that prior lien. And then I think the lawyer has to think about confidentiality, right? I mean, we have a duty under RPC 1.6 to protect all information relating to the representation of the client, right? That includes everything. It includes stuff protected by the attorney-client privilege, but other stuff that could be embarrassing or harmful to a client, or that your client has asked you not to disclose. So in this circumstance, you may come to the conclusion, I can't even tell this person whether or not I have funds in trust, because disclosing that I have funds in trust is going to disadvantage my client, right, under RPC 1.6. So you need to think about those types of issues. I was going to tell you about this case in Washington. That's sort of an interesting take on this issue. It's the mayor's case where there was a garnishment served on a lawyer. The lawyer said, oh, there's no funds held in trust because those were sort of earned upon receipt fees and they've been transferred over to my general. And then he said, okay, well, it was a fraudulent transfer then and I'm going to sue you. And then he's like, oh, no. That's just client money. And the court was very unhappy with this lawyer under those circumstances. So I'm just going to quickly move on to hopefully to sort of try to tie this up a little bit. Taking security interests. One of the big questions is whether or not a lawyer may ethically obtain a client's agreement for a lien on real property in the future to be awarded in any kind of divorce settlement or case or resolution. And I have not seen really direct Oregon authority on this topic in terms of cases where lawyers have been suspended because of this or publicly disciplined in any kind of way. And there's really no ethics opinions that I know of in Oregon that say lawyer can do this in this context or lawyer can't do this in this context. I think the general authority nationwide suggests that a lawyer can do it in these circumstances if they follow certain procedures. RPC 1.8I allows you to acquire a proprietary interest, tells you cannot acquire a proprietary interest in the cause of an action that you're generally conducting for a client, right? Because doing so would normally create a personal conflict of interest, but there are two exceptions. One, where it's a contingency fee, and we're not going to talk about that anymore. But two, where you acquire a lien that's authorized by law to secure the lawyer's fee or expenses. And comment 16 to the AB model rule, even though we don't have the comments in Oregon, we look to them for guidance, states that liens authorized by law may include liens granted by statutes, liens originating in common law, liens acquired by contract with the client. Okay. And there's an ethics opinion 02427 that talks about this in a little bit of detail. And recently there was an ethics opinion out of Michigan, RI-376. It was issued in December 2017 that confirmed that a lawyer could do this, generally speaking, and take a lien in it, so long as they comply with RPC 1.8a, which is sort of the doing business with client exception or rule under the RPCs, so that you have to disclose to the client that the transaction term, disclose transaction terms of the client, make sure they're fair and reasonable, that they're transmitted in writing that can be reasonably understood by the client. Client must be advised in writing of the desirability of seeking and given a reasonable opportunity to seek the advice of independent counsel, and they have to give informed consent in a writing signed by the client to the terms of this transaction. So you really have to disclose it to the client, make sure they understand it, and what it means. The two really important points about taking liens, particularly I think for you all, is first of all, I think you have to think about the conflict of interest involved in taking a lien in the case, right? It's not just doing business with the client, but suddenly you're invested to some extent in how this case resolves, right? And you need to think about whether or not that investment in the case causes a material limitation on your representation and personal conflict of interest under RPC 1.2 A2. And I think disclose that to the client and talk about it. And in the course of the representation, you have to think about whether your representation is being limited by being able to see what this outcome could be. But really notably, this lien can't cause prejudice to the client, right? It is still subject to what's in your client's best interest. And you may have to release the lien or give up the lien if it would hurt your client in the settlement or the resolution of this case. And so you may be able to agree to a lien on the front end, but that lien may ultimately not have much weight at the back end if it could impact your client's ability to settle a case or resolve a case or anything like that. And of course, 1.5, you must be reasonable and not clearly excessive. Any questions on that? Okay, I probably only have about a minute or two left, so I'm not going to go through 1 minute. I'm not going to go through all of my 5 things to remember, which were brilliant, and which you should all read later. They're really great. There's a piece here about third-party payers. I think it's really important to think about third-party payers, especially for this group. You have people who aren't your client paying your bills. You should understand that you have to comply with 1.8F. The client has to consent to it. And they can, you still have confidentiality requirements, and they can't, they're allowed a seat at the table, but they don't get to control what you're doing. And so talk to your clients about that. I even recommend that you get that third party to sign something acknowledging the confidentiality limitations. And I think one of the most important issues with third party payers that I see often come up is third party payer pays a bunch of money into the trust account, and then you stop representing the client, you still have money in trust. What do you do with it? Who do you give it back to, right? Do you give it back to the third-party payer? Do you give it to your client? And I would make that clear in your engagement letter and in the third-party payer agreement that you have signed to whom that money goes to at the end of the case, so there's no dispute at the end of it. And then I guess as a final note, I will say that it's better to try to avoid fee disputes in the first place, right? I mean, you are a group that passionately represent clients, but who also with criminal defense lawyers receive more bar complaints than any other group, right? And it's not because you are not as good at lawyers, obviously. There are lots of factors that go into it. And one of the things to always remember, I think, is what we can do practically to limit that. So much of this revolves around money, right? And so I think it's really important that you talk to your clients about fees early and often, right? Don't be afraid of the engagement agreement where you talk about it. Don't be afraid to ask for advance deposits, because advance deposits ensure that they want you to do the work and that you'll be paid for the good work that you do down the road. Well, always call your clients back, of course. Watch when good clients go bad, right? Because a client might pay your bill over and over again and then stop, and you think, oh, it's not a big deal because they pay their bills. But monitor those types of situations so that you can react quickly to clients, so that you can avoid issues that may be sort of growing or resentment that's within a client. So really monitor your clients. Be mindful of red flags that come up in a case and also with your clients. And I guess finally, know that you don't have to take every case. I mean, oftentimes I represent a lot of lawyers in discipline matters, and oftentimes I knew from the moment that client walked in the door, that client was going to be a problem, right? So trust your instinct a little bit so that you can avoid fee disputes, malpractice issues. And although John doesn't want to call me, I love talking to all of you, so feel free anytime. Thank you very much. I appreciate it. Have a great day.
Thanks, David. Great job. We're going to hear from our next speaker, Paul Sosi, 3 different times over the course of the conference, so I'm only going to give you 1/3 of his introduction. You know Paul from his presidency of this organization, the Family Law Section. You know he's been practicing almost 40 years in Salem at Sosi & Sosi. Very successful. His forums are everywhere. He continues his service to our organization with his series of quick points today. First one will be about life insurance. Paul Sosi.
Thank you. So in 2010, Paul DeBass gave a presentation on the importance of life insurance. And when he did so with his excellent materials, he raised the standard of care that we as practitioner attorneys need to meet. My point today is to try and increase that a little bit more by showing you how to make that functional. Now, Paul's materials are in my materials, and you'll wonder why this is a quick tip, but maybe the written materials are 50, 60 pages long. Well, you'll see. In practicing this presentation, I discovered there was a problem. And that problem is that as I talked about various points, people's heads went down and they began reading my written materials because I'm only going to hit the high points because that's what this is. These are hot tips. So I'm going to move fast like it's a hot stove. So don't look at the written materials as I go along. Look at them later. My point here is it's like taking a bar exam. We're doing issue identification. So we're moving along with it. So the first thing is, do you have to mention life insurance? And the answer is yes. There's a statute that says in the judgment, you have to say something about life insurance, even if it is, there's no requirement that in this judgment that there be life insurance. But you have to start thinking about the things before you get to the judgment. For example, you agree to provide insurance, but then you find out that the husband's not insurable. Oops. The next thing is, how much is it going to cost? If it costs a lot, then if it costs a lot, you should know that because you can say to the court, I want to reduce the child support by the amount of the insurance. Next thing is this insurance really necessary? And I talk about this in my materials. What is it for? There are lots of folks that are wage earners, and if they die, they're going to have Social Security death benefits available to the child until the child's 18. Maybe there's no need for insurance. And I have several examples in my materials about what that is about. Then who should own the policy? Should the husband, and I'm being very stereotypical here, assuming the husband is going to be the insured life, should he own it? Or should the former spouse own it? Because then they can make the payments. That way they assure that it's happening, that the insurance is in place. They get to name the beneficiary and it becomes an asset later on. There are some old forms out there that people still are copying. And it says that the children shall be named as the irrevocable beneficiaries of this life insurance. That is a huge mistake. Irrevocable means irrevocable. Don't do it. Should you name the child beneficiary? The answer is no. No, no, no. Don't name the child. And in my materials, I explain why, but let me tell you a story. I had a client come to me and she said, good news and bad news. Bad news is that my former husband was killed in a car accident as he was driving to come pick my daughter up for parenting time. The good news is he had the life insurance in place. And I'm so pleased because it's been a financial struggle for me. And now I'm going to take that life insurance money and I'm going to buy a duplex. I'm going to live in the half of it, rent the other half out. It'll be a great investment, et cetera, et cetera. And I said, no, you're not. The insurance company is not going to pay money to a minor child, and he named the minor child as the beneficiary. The insurance company required that a conservator be appointed. That conservator was a bank because it was a good amount of money. And the bank then monitored the money for the young daughter over a period of time. Eventually, the bank decided to buy a house. The house belonged to the daughter. When the daughter turned 18, the daughter had a 25-year-old boyfriend or something, and she gave mother notice that I want you out of my house. I'm not kidding. I want you out of my house, and I want my money, all of it, to the bank. There were some other complications involved, but you see what the dynamic is. In all those years, the mother had painted the house and kept the yard up. Guess what? It's not your house. So who should you name instead? Well, a lot of people name the surviving spouse. I mean, the former spouse, especially if it's a smaller amount. You can name a third party. As I say in my materials, the mistake on a third party is if you're the one who's going to benefit from the insurance, you need to make sure you have some say in that third party, because if your former husband names Trixie the new wife and you have to go to Trixie every month to get a check, then, well, you can see the problems. You can name a trustee. Who would be a trustee? It could be an individual. It could be a bank. So who should I name? There are lots of folks. My materials talk about it. All right. What should the judgment say? Lots of options in my written materials. One is we're not saying anything about insurance. We're not providing it. Another option is the man doesn't have insurance, but I'm going to buy it. So it says $100,000 of insurance, blah, blah, blah. And sometimes the judgment stops there. That's a mistake, as you'll see in a minute. But if it goes a little further, it says you're going to buy the insurance and you're going to get it within 60 days. And then we're going to submit a supplemental judgment that has all of that information in it so that you can see how that goes. Now, I've got forms for the supplemental judgment in the written materials because my assumption is you don't want to send your 25-page long general judgment with the custody and all those other provisions in it to the insurance company. So what do I do once that judgment is entered? The judgment has to have specific information about the policy. It cannot just say $100,000 of insurance. It has to say standard insurance policy number such and such for $100,000 payable in this way. If the insurance company doesn't get that kind of instruction, as explained in Mr. DeBass materials, it is not bound by it. So who provides the notice to the insurance company? And the answer is the person who's going to benefit from it. I see a lot of judgments that say, well, husband's going to get this insurance and he's going to give it to the insurance company. Like you're going to trust him to do that, right? But the statute very specifically says that the person who's going to benefit by it is going to do it. So how then do you prove that the insurance company got the notice so that it is bound by it? And they don't mop until 10, 15 years later when the guy dies. I'm assuming that your file has been purged. You haven't kept the green registered mail card, or you maybe gave it to your former client and she's lost it now. How do you deal with it? Well, let me take advantage of Odyssey. It's a computer that lasts forever. This is what we do in my office. We dummy up this document called Certificate of Compliance. The full copy is in the written materials. We attach to it the letter that we have sent the insurance company and the green card that came back that said the insurance company got it. And we attach it to this document we've dummied up, and we file it in the Odyssey. We filed it in the case file in Odyssey. And Odyssey takes it. Great. Now I can purge my file and I don't have to worry about it. And 10 years from now, when the guy dies, my client, former client, can prove that the insurance company really did get that notice. So, one other thing about the form. A pet peeve of mine is that some lawyers really like to put in the final general judgment a statement that says that I, Paul Sosi, am now relieved as an attorney of the case and I'm no longer representing Mother Darling. They put that in the general judgment. I think that's really stupid, because as soon as you do the supplemental judgment for the quadro or the supplemental judgment for the insurance, you're back in again. What I do on this notice is you'll see there's a bold statement that says, I'm providing this for notice purposes only. I withdrew. I'm still withdrawn. I am not the attorney of record. This is just for notice purposes. What about group life insurance? I'm in Salem. I'm in Salem and a lot of the state employees have insurance, and you send off the letter to Prudential and they just don't even respond. I talk about that in the written, how you deal with that. What about provisions that detain you as the beneficiary? What about that? Be very your end of case letter is closing your file. What you want to do is to pass the lock to your client. Look at the provisions in my written that you check it to make sure that this insured or Trixie's now named, or thing they'll do is you want to cover when that client, what about this? Hey, yeah, I told you. And you make, at that point, the clients are out of attorney fee monies. They're not more in the last issuance of a to send to the insurance company. Not a problem. The thing is, has insurance company no. Well, if everything goes the way the company will contact your client and say, he changed the beneficiary or he premium payment. What can you do? The statute specifically gives husband, and then you can sue the husband. That's insurance.
Thanks, Paul.
Mike's off.
But AVO review, and they're all positive. Calls attorneys. I don't disagree. Thanks, Paul. Our next presentation is on working in opposing parties. We have two. First is the Honorable Love from Lane County, Hawaii. Went from there to Linden College. Spent a couple of terms in the attorney's office. From October, I had to go all. In any event, the youngest of 4 children, had a strong tradition in her family of going to college, and she went all the way under a degree in political science. After achieving that degree, the Pacific Northwest earned her in Clark Law School in 1984. Firm until she graduated and became a full-time, and then she continued her practice until she was appointed to the bench, where she's now the senior chief.
Those are all things for you to look at later. And emissions is for positions. You have you respond to all the requests. Positions and with intellectual honesty about, and you come up with some solution. Actually have clients, each of you that have where to their first appointments and can be in this way, you can be and any point adverse experiences. So they have resolved have the adverse and or has done the work that they need to do to overcome any unresolved grief issues. And they are in fact, you want to try, you get a result right then that's fair, and everybody says, oh, this is because you're
Okay.
like 8. Okay, so that's one route. The other, you doesn't know straight up out of a barrel about conversations go when you're in front of the judge. An email, but did you read the email I sent you? And then the judge says something like, have you actually tweeted? Say, that's one of those kind of guys. And I just said to life miserable, motion that I can possibly file. And then I took a breath and I thought, am I actually doing that? Not my client. So I would like to suggest to you that one of the things that I have learned in my judicial career, represented people for reasons that are utterly unclear to me if they have money, but very clear. Self-represented people choose to represent themselves. They don't have 0 as a general rule on the adverse childhood experiences score system. They don't have a lot because since all the lawyer jokes in the world. And it's hard when you're trying to get a fair result for your client. And it's hard when you're trying to get a fair result for your client. And I will suggest just do everything as if it was a really bad lawyer on the other side. Because you're not getting advice, you're actually just making sure that you need to make in order to protect your client, but you're not actually over because you're an officer of the court, right? And you have certain jobs are done in the law. One of the things that became as a judge, something percent of the county families, one side is self-represented. So, but the single frustration is, unlike a person, there's nobody out in the hallway that is managing the expectation about anything. And so when somebody comes to the court to order joint legal custody and the judge says, I don't have authority to do that, who does? You got to take a breath in and out and not come over your bench because, their robe, what they're doing is trying to understand the system. And there's a different meaning and giving legal advice. And we're going to talk about that, procedures and things. So.
And I think I would agree. How many of you come from jurisdictions where you appear before the same judge once the family? And then how many of you go through, depends on who's available or the docket. We're more like that, where we could get time. And I think who are the ones who, this is their 5th modification or something like that. And they may have had multiple lawyers and think, well, I know now. You have folks as well who, like Judge Tennyson said, they probably aren't going to have the means, and they have a lot going on to think that if someone heard their case before in court, somehow in that hearing was absorbed where. And it's a thing, and we go back to law school about what it took for practice, about and then we took that and most often to the what actions, how's this going to work? How's this going to impact my life? They're in a really, really difficult point. Then you throw them into a court background, them through, and everyone's anxious. We all get is for everyone. So kind of keeping that in mind, I think helps when you're having to work as with a self-represented party. I think there's a lot of things that, there's training on what you need to do, documenting all your conversations, kind of setting ground rules, how you're going to communicate with each other, that you're not giving them. I think one of the things that we want to stress, at least leading up to when you get in the courtroom, is make sure your discovery is in order. I don't know that, pro se and what the discovery. On occasion, you get someone who just comply with anything, court order. But I think often an unrepresented party is overwhelmed. It's a lot more on the other side. So don't be afraid to bring something before the court if you need to compel. So don't be afraid to look to a judicial settlement conference if you want to try to get some assistance to see if you can resolve the case pre-trial. Like Judge Tennyson said about trying to manage expectations for unfamiliar with this system.
So I think settlement conference is for you to explain the situation to an experienced either lawyer or judge talk to the other. What I can do for you in a settlement conference that I at a trial is I can talk from my experience. I can give advice, not give advice, but I can inform experience. And around for a while, I was a lawyer for 18 years, 16, almost 16 and a half years. However many years that is, math not being my strong suit, all of you in front of me when I make you do the equalizing judgment calculations, because I actually can't. So, professional, I know about development, about high conflict families, about family violence, about mental health, about drug and alcohol issues, which I can actually use when I'm trying the information that I'm in a settlement conference. The judge's experience to help in the program that we have now in Multnomah County, where we have really women in every Wednesday to help parties resolve cases, and they've taken some that I have folks who are unrepresented to very. So do not overlook the settlement conference. One of the secrets, a judge's decision information we have when we make it, and how we get that information is controlled by a tight set of rules and really depends on you. So do make sure that what you're doing when you're getting ready to try a case is that you have the information you need in court that will support what your client is asking for. So what that means is, if you're not getting discovery, file the motions you need to file in order to get the information that you need. Set this up so that what you need, or finding a way to do it. So just because you've got a self side doesn't mean what you do is lay down in that regard. You've got to make sure you're getting what you need to make to present the case that you need, or to even be ready to have settlement conference. So
yeah, definitely don't feel like you're frozen simply because you have somebody on the other side who doesn't have an attorney. I think we're ready to talk about trial.
not quite. I think the other thing we need to do is
That's why I asked, because we have more years on the bench.
I think that one of the points we wanted to make is to handle these situations with care. So that's not what we're saying that you shouldn't come over the top. should remember that we as lawyers and judges talk to each other in tones of voices, using words that normal people do not use. I myself, as you may know, am banned from talking to anybody doing remodeling on our house. They don't like to be cross-examined about what the sequence of the doesn't, there it is. So what we do is remember that we are using words, like one of our principles as lawyers is for people who don't understand what they're using. And so some of that is very much part of why it's important that you pick your tone and pick your the way that you are going to address the issues related to self-represented people. And you can have your inside voice, and then you need to, with your letters and your tone and your everything, use your outside voice that will allow you to be rational and responsible about how you're communicating, because ultimately what will happen is the judge will sort it out later if there really is a basis for attorney fees. And believe me, I've awarded them in cases where self-represented people have just caused a mess because they refuse to see the light. So it is a situation where your best chance at preserving lots of things for your client is to take the high road.
Which I think is always a good rule. If you have a difficult, just uncooperative, self-represented party on the other side, it will come through. I mean, it's going to come through. And so always taking the high road, being professional, I mean, that's a rule that we should all work by anyway, but these cases can be very taxing, right? They just take a lot of time and a lot of energy. And so knowing that going in, not only do that when you're a pretrial, but how you conduct yourself in the courtroom. And, while you have your obligation to your client, especially if you have children involved, their families are going to have to live and figure out how to co-parent and how kids are going to be doing. And the less toxic the process can be, I think the better off everybody is in the long run. So.
One other little sidelight that we want to go down is when you have unrepresented people on the other side, and you have information that perhaps they lack capacity. And this is going to become a bigger deal as the baby boomers continue to age into their dementia years. And I could get into the statistics about that, but I won't. But you need to make sure that when you are asking for defaults, that you actually do have a basis to represent to the court in your declaration that you have no reason to believe that the person is incapacitated within the meaning of ORS 125.005. And there is a method for getting guardian ad litems appointed through ORCP 27, and you should be paying attention to that. You should especially be paying attention to that if what you are hearing from your client is that the other side was like this perfectly normal, rational person, and all of a sudden started to take money out of the 401k and spend it wildly, that there is evidence that would suggest that the person is participating in some things that are completely out of character, like sending money out to win the Mini Cooper to Nigeria, that they're responding to random princes from wherever. So be very careful about those kinds of situations, and be willing and able to recognize that perhaps the person on the other side doesn't have capacity and that you need to take the extra steps. Again, this is a protection for your client, because any default that's taken where the guardian ad litem or the conservator for the person that you've taken the default against can come in and say, hey, this person didn't have capacity, then all the steps you've taken to get the judgment your client wanted are out the window, and we're right back to square one. And the other thing that you need to make sure that you have a clear understanding of is the RPC involving diminished capacity representation. It's not a substituted judgment role that you're playing. It's a how do I make sure that I'm talking to my client in a way that makes sense. So if you have a client that you're worried about, you need to also make sure that you've got somebody on that you're representing that has capacity to give you direction. And if not, you need to take the steps that are going to protect that person through the proceeding. And you need to be especially very careful of children coming in and saying, my dad wants a divorce, my mom wants a divorce. Usually these are in circumstances where you have second, marriages or third marriages and children from the first marriage who are trying to get things set up so that they can preserve the estate that they want. So anyway, you just need to be aware of those kinds of fact situations, understand who your client is, and make sure that if somebody on the other side of the case appears to be impaired, that you take the right steps to be able to make sure that what you're doing in that case is going to stick. So, okay,
All
now,
right, thank
you
you.
want to talk about trial?
Yes, all right. So trial, again, really stressful time for everybody, even your client that you're there with. And so one of the things we want to stress today is, and you should always do, but it's very, very helpful when there's an unrepresented party on the other side, please come prepared with a proposed judgment. Mark your exhibits, please have a trial memo. It not only helps the court, but it's also something that the unrepresented party can actually take a look at. And it's something that is everybody can have in common to go back and reference as you move forward through the trial. And so it is much more complicated to try to manage that courtroom and manage the flow of information and move forward. Really important. If you want to have proposed findings of fact, come prepared with what you can, everything that you can, and it just makes it go more smoothly. And again, my jurisdiction, I don't know what I'm getting till about 10 a.m. each morning. I think you would at least get the memos a day before. But again, it gives the unrepresented party a point of reference, and we can, try to move forward more efficiently with a trial. I think both Judge Tennyson and I, when we're having to try one of these cases, give some procedural information at the outset. And sometimes I think attorneys might perceive this as trying to be helpful to a pro se litigant, unrepresented party. It's really just setting the ground rules for what's going to happen for somebody, especially who has no idea how this is going to go. And so I usually start out by asking the parties if there's any agreement, try to go through where it appears we're at from the pleadings. If they've reached an agreement, to put that agreement on the record so we know what issues are left. And then talk about how the evidence flow is going to go. And then exhibits need to be marked. And really that we're using questions and answers and how the order is going to be. And that's one of the hardest things I think for unrepresented parties to do, at least that I've seen, is to go through that question and answer process. That's not how we talk every day. And especially when individuals have had a history, they often want to start talking at each other. And so that's something that we're always having to constantly manage. But I think most judges are going to give some procedural information to try to provide the forum so we can get information and move the case forward and provide access to the process for the unrepresented party. And I know that your method is a little bit different of how you go about that, but I think that might be helpful to share.
So one of the things that you should know just from a 30,000 foot level is that, and if you aren't aware, you should Google, not now, but later, procedural fairness. It's the buzzwords that are being used in every state in the nation by the judiciary right now as the ticket to allow people to have more faith in their judicial system. And the idea behind it is that when people feel heard, and this is what the research says, when people feel heard, they are more likely to be okay with the outcome, even if they don't win. So there are many, many things that we do that we just do because we do them, and we don't actually explain them. And so one of the things that you will find, I think, is that judges in Oregon have been getting this training now for 4 or 5, 6 years, something like that. We all have developed sort of the pattern that we use when we have one side that is unrepresented. And I do have a slightly different process when I have 2 unrepresented people. But when I have one side represented and one side not represented, I will, in fact, allow people to ask questions and offer that. I don't always offer that when they have two unrepresented people in the situation, because I don't really find that the cross-examination goes very well, because sometimes it goes like this: well, before I broke your leg, what did you tell me? And it's like, this is not a good question to be asking. The Family Abuse Prevention Act restraining order. Anyway, so what I will say to people is, here's the structure of how this hearing is going to go. These are the rules that we're going to follow. you need to make sure that if you're going to assert an objection, that it's not just, I don't agree, that's a lie, or anything along those lines. And you don't interrupt me ever. So it is one of those things where if you're setting expectations at the beginning about behavior, what you hope is that people will follow it. As a general rule, what ends up happening is that people either try to do cross-examination and fail. After 3 chances, they then lose their turn with that witness, or they just kind of get, they understand that there's no possible way they're going to be able to actually ask questions of that witness, and they just wait to be able to present what they have to present. But one of the things that I would really appreciate some help with, quite frankly, from you all is helping to facilitate exchanges of exhibits. Because that's the thing that takes sometimes the longest when we're getting ready to try a case, is the part where everybody's handing exhibits back and forth, even when I have 2 lawyers. So it would be really helpful if what you would do in these circumstances, you're going to offer them, they get to see them. So let's just get that done maybe the day before, a couple days before the trial is going to start, so that everybody has an understanding of what the documentary evidence is going to be. And then you can move forward in a way that makes a lot more sense, in my opinion. So I do a lot of explaining about procedure. I do very little. Let me just say this. This is a really tough issue for judges, because we need to have information to make a decision. And on the other hand, we can't help. And so you are going to, over the course of your career, find judges who have different methods and different lines that they either do or don't cross as it relates to the 2 competing things that we're talking about. For me, if it's a child, I'm as a general rule going to be more inquisitive and try to get underneath what's going on. If it's a money thing, I'm less likely. I had a case recently with 2 self-represented people who actually could have afforded to hire lawyers. And the one spouse came in and said, hey, I know I need to pay spousal support. Here's what I'm willing to pay. He had it, all categorized. And this is what I think is fair. And the other spouse said, I should get compensatory support for having the child $20,000. And then I should get transitional support because I'm in school right now. And when I get out of school, I'm going to get a job. Well, what kind of job are you going to get? Well, I don't really know what it's going to prepare me for. Well, do you have any idea what your salary is going to be? No, I really don't know. What do I do with that? Except, the only evidence on the record is what he's willing to pay and why he thinks that that's the fair thing to do. So, these are very frustrating times in many respects, because I didn't grow up in a world like this. I grew up in a world where everybody really had a lawyer. Nobody thought they could do it themselves, and they certainly didn't think they could watch Judge Judy and figure it out.
Or Google. Right? The internet is, so many people use that as their lawyer anymore.
Right. So I would say that, it's hard on us, and you can help us by being prepared to present case and make sure that you understand what your ethical obligations are as it relates to what is okay to ask for. So
I think one of the things also when you're in trial is do your best, if you can, to try to use plain English. We all, again, got trained, and anymore, I'm often asking in custody cases if it's okay with the parties, if there's a lawyer asking if they mind, to refer to the people as, parents, mom and dad, or something that makes it more human and less formal. We're still in a formal proceeding, but again, how can we move this case forward? How can we provide access for folks in a way that they can understand? Again, not trying the case for the person, but again, trying to provide that procedure. There's lots of boilerplate that goes into judgments, and that can be complicated for unrepresented parties, especially if the first time they're going to see it is a judgment that gets submitted after the trial. That can cause a lot of angst for folks. So to the extent you're able to, consider that. I think also when you're in trial, one of the things that comes to mind a lot when I have a case with a lawyer on one side of a domestic relations matter and an unrepresented party is going back to, evidence 101. You first learn when you can object. Then you learn when you should object. And I think this gets missed sometimes when we, are in these stressful situations. It may have been very frustrating with an unrepresented party, whether they're being difficult or just because they don't know, but getting to trial, trying to work to move forward to get to trial, you may be at your wit's end by the time you get to court. And so what we see sometimes is objections, and they may be valid legal objections. But when you have to take a look sometimes at what's going to come in potentially, I sometimes wonder, why are they fighting about this? This is actually helpful to the client, but you may just be, kind of on autopilot wanting to object when it's something that's not admissible. Another thing that we see is when a pro se person offers something that's inadmissible, don't try to offer the same thing that you know is inadmissible. That just, it doesn't go over very well, and it's something that I've seen more often than I wish I would see. And so we're watching for that. I don't know if you want to share some thoughts on that particular issue.
Well, I just really feel like sometimes in any trial, lawyers are not actually listening to the answers. And sometimes the answers are really helpful to you. And so objecting non-responsive or whatever it is that you do is like, whoa, why would you want to strike that? Because wow, that was a great. So the same thing happens with, I think, with self-represented folks. Early on in my judicial career, Judge Specky said to me, when you're hearing a case and you can't really figure out what's going on, just let the people keep talking. Eventually, they're going to tell you what really is happening. And sometimes with self-represented people, it's the same exact thing. Try not to let them, understand, first of all, that not everything that they're repeating that somebody else said is actually hearsay, because it's not really being offered for the truth of the matter asserted, but only to show why they did whatever they did next, or that a statement has been made. So just let them talk sometimes. And then what ends up happening is they're going to provide you with a kernel or a nugget that you might be able to use later in connection with how you're trying to, what your goals are for your client. So that isn't always true, and it really depends on the issue. So for those of you out there who have to defend against claims related to abuse or neglect of a child or otherwise, sometimes you need to be very technical about that, and I understand that, and I think we all understand that. But there are certain things that, people come in and they want to have an accounting for who bought the last bag of dog food. And we all know that no judge should really be caring about that. But it's important for the person to say, and then the judge can explain, judges don't really do accountings, although, well, don't get me started on the Court of Appeals, but, oh yeah, this is being recorded and that was my outside voice, sorry. Anyway, we just don't account for every detail of every expenditure, and we will explain that to people in a way that they can hear it, hopefully, so that we can move on to what the bigger picture is. All right?
Mhm.
Okay.
Pick your battles. I mean, I'm just thinking back to a case where, again, going through, something was objectionable, but I had to look at the entire long document, and it actually would have been helpful to the other side. But we spent so much time in court over that battle. You have a paying client, that's money out of their pocket. And so really being mindful, I think, of picking what battles you need to pick. And again, you have your obligations. We realize you have your duty to your client. You need to make your record. Your lens is a little different, but there's a lot of times where it just seems like there's unnecessary fighting over things that goes on that's not helpful to the case. Getting overly dramatic in the courtroom doesn't help me understand what's going on and what the evidence is. And so just, be thoughtful about that when you're trying a case. 9:10 or 10:10.
10:10. Okay, so we have a lot more time. All right, so what you should be doing now is thinking,
Or
do I have
10:05.
questions for these judges? And because we're willing to answer them, so go to the microphones, please. Otherwise, we're just going to kind of keep talking. Yeah, go ahead. Yeah,
Yes.
that way we don't have to repeat it.
So I practice in Lane County. One of the issues in dealing with pro se litigants that I find in court is that I find myself not objecting, doing the opposite of what you're warning us against. And oftentimes, usually it's just to get through case as quickly as possible, get information, and knowing that an objection is going to create more difficulties. But then at some point, invariably, there's a look from the judge that says, are you going to object?
Well, maybe the relevance objection at some point.
Yeah.
Something
we've
like
got
this.
way down.
Yeah,
Yeah.
or enough is enough. And, there are times I say, okay, it's, a little too much hearsay, I'll object. But when is too much, I suppose? I mean, when do you think it is important to
So sometimes
rein in a pro se litigant?
Yeah, so sometimes what I would say is that you can assert a cumulative objection most of the time when people are talking. And so what I try to do is help you out by stopping the person and saying, okay, here's what I've heard you say. And then I repeat back sort of the highlights of, now, do you have anything new you want to add? And sometimes that works and sometimes it doesn't. And if it doesn't work, then what you need to do is start objecting cumulative, because people just have a tendency to just repeat. That's the biggest problem with self-represented people, I think, is they just, for some reason, they're nervous. I mean, I didn't really think about it this way until I was at this training where a woman was talking about the fact that if you think about your courtroom, it's basically your living room. You're in it every day. You have all the things on the walls that you like. Your desk is set up the way you like it. You're very comfortable in it. No one else is. And so once I got that, then I started to shift my thinking just a little bit about how to approach some of these cases. But I think you can, if you get in the eye from the judge, definitely, open your mouth because we're going to want it. But also the judge does, ultimately we do have the responsibility to control our courtrooms, and we can interject and try to move things along. And I really have stopped doing the really obnoxious things that I used to do. Like I would assert objection asked and answered, sustained. And then I would say, that would be me. That would be all me. So I've stopped doing that because now what I say is, I think what I've heard this witness say is X, Y, Z. Did you have another question you wanted to ask? Am I putting words in your mouth? I say to the witness, no. Do you have another question you want to ask to the lawyer? So I'm trying to be a kinder, gentler. If you can choose anything in this world, be kind, choose to be kind. And, I'm not perfect about that, but I think that every judge has a style, and you also need to know who you're appearing in front of, but that's a whole nother talk that we can get into some other day.
Well, and I think every judge has a different comfort level with how much you do in court to control the courtroom. It depends on how long the trial's been going on, whether I'm going to kind of try to move things in a different direction. But I think too, you may have had this experience with clients who want to be telling you everything about how they got there, their whole life experience getting to the point where they've had to come see you to ask for help. It's no different for somebody who's not represented. They think they want to share their entire story, and it's hard, I think, sometimes for them to understand we're only doing this today. All of this is not something that we're going to be hearing. And so again, they're managing expectations is really, really important, but they just want to kind of get everything out in the courtroom. And so sometimes we have to redirect. So yeah, long looks can be a clue that please maybe do something, but it's just being thoughtful about, there's times where maybe you don't really need to get, if you're objecting every 30 seconds, please, that might be a bit much. But you have your obligation and you need to make sure you present your case appropriately. But often we just need to try to figure out how to streamline and move things forward a bit. And that's one of the biggest challenges, I think, with these cases.
Alex.
Austin. Thank you, Judge.
Sorry,
It's all right. It's all right. Every time. It's okay, Judge. It's all right. My name will be the same. It's all good.
Austin, what would you like to say to
Hi,
the
Austin.
Hi. Nice. Thank you. My question goes back to pre-trial and communicating with an unrepresented party and best practices around, I find that unrepresented litigants hate getting letters from me and emails from me, and they let me know that. And so how to sort of temper those communications in a way that is also moving the process forward. They always want to talk on the phone, so then I'm sending a summary saying, for this conversation, if it's someone I even think I should have a phone call with, which again is not usually very often. And so in the written communications for my CYA purposes, what is that balance of not giving advice, but also saying, as my understanding of what trial will be is focusing on these issues. I understand you have concerns about these other issues. However, it is my understanding of the law that a judge is not going to think that those are pertinent to the judgment. And so, again, like, how should we frame that? How do we do those things in order to not put the burden on you and have it be like, well, she tricked me because she never told me this is what's happening. And then it's just 10 minutes of them talking about how I'm not a nice lawyer. So again, how can we set you up for success in those situations?
What an excellent question.
Thank you
Austin.
for being concerned about that.
That was an excellent.
Maybe now you'll remember my name.
I never forgot.
I just have 4 words for you: age-related cognitive decline.
I think it's you have that tricky line, right? Between trying to streamline, give some procedural information, if you will, but something that's going to maybe be taken as legal advice or crossing over into that line. Do you send a letter out at the outset of your case saying it's really important? I represent this person, communication, if we have to do it, I'm going to, do a letter so that, we're on the same page with what's going on? Or do you send that type of communication out at the outset?
I do.
Okay. And still, sometimes you give procedural information like we do in trial, and we hope someone's going to listen, and it doesn't always, take. We have to keep reminding. I think it sounds like you're trying to be really thoughtful about what to do. I think you could focus it maybe on saying, these are the issues that we understand are going to be important to the case and we're going to be presenting. And, the judge may or may not consider that. It is a really, really fine line. And so I'm not hearing anything you're telling me that's causing me to go, ooh, but of course, I'm going to now defer.
Yeah, I just would always make sure that you've got that tagline at the end, I don't represent you. If you have questions about your own rights in this case, you should consult with a lawyer. So that's in every letter. I would strive to make sure that my letters are neutral in tone with regard to, we just had this ridiculous conversation. Don't do that. So say, this is confirming our conversation about wherein I advised you, blah, blah, blah. And I would say these are the things I am focusing on behalf of my client because I believe that's what the law requires. I know that you are concerned about X, Y, Z, but I don't think there's any legal basis for that. I think you can say those things, and don't say the judge is going to do this or the judge is going to do that. Just simply stay focused on what your theory of the case is. You're not giving legal advice. You're simply saying that our position is there is no legal basis for what you're asking for, or what you're concerned about, or whatever that is. And then, but don't make them lengthy. I think communication with people needs to be short and to the point and respectful. And try very hard to stay away from arguing something if you can, because you're going to state your client's position and that's the way it is. Does that make sense? Okay. Next question.
Yeah, so maybe Judge Raines can help with this, but I thought there at some point was an SLR in Washington County that says they won't do settlement conferences with an unrepresented party. Maybe that's changed. But so I'm a fan of the settlement conferences. But one thing that's nice in Washington County, at least on pre-judgment matters, is you also have status checks prior to trial. And I know, again, with Judge Raines, that can be a time when you have an unrepresented party that Judge Raines is really receptive to the attorney saying, Judge, I'm concerned that Mr. So-and-so isn't understanding that the court's going to be applying certain factors when they decide who's going to get custody here. And Judge Raines is really good about kind of going through and just saying, okay, here's what the court considers A, B, C, D. So that's one way that I felt is helpful also to deal with the unrepresented parties. But the other thing too that I've recently discovered is the informal domestic relations trial. And I found that I just had one with an unrepresented party is a way that the judge could also kind of take more control and really get the information that they need to get. And so I'm just kind of throwing that out there as some other options.
I mean, the
So-
informal trial, I think, is representative of the way a lot of unrepresented parties come to court anyway, with, you know, a stack of documents or things they want you to look at and think you're just going to take it all and tell you their side of what happened. And so it's a nice alternative to have that really mirrors more of what people come in prepared with sometimes.
I would just say about I don't know if there's a rule or not in Washington County about unrepresented settlement conferences. They happen regularly in Multnomah County, and if you can't get a judge to do it where you are, certainly you might be able to get a lawyer to step in. But to me, that just is the best place to try to have that. Whenever I do Family Abuse Prevention Act restraining orders, for example, or any other kind of case, I set out for people what I am looking for. So, for example, in a FAPA, I'll say what I'm particularly interested in, because it's what the statute requires that I have information on, is what incidences of abuse or threats of harm have occurred within the last 180 days and why you were in fear of imminent harm from the respondent. So, and then I set out the same sort of thing for the respondent so that they understand what they need to be responding to. And that way you sort of avoid hearing many, many, many things that you may not otherwise need to know. But I also include the catchphrase, but anything else you want to tell me. So again, we're all walking a very, very fine line as it relates to what is admissible and what isn't, and what people have to care about and what they don't. And sometimes people have got to give you a backstory so you can understand where they are right then. And some of us are better at others in figuring out what's going on with less information. And you, again, need to figure out who you're in front of and what they need in order to give the decision that you want them to give you. So, if that makes sense.
So is this on? Can you hear me?
I can't
Hello?
hear very well.
I don't hear anything. Okay.
There you
Oh, there we
go.
go. So this is kind of a two-part. In preparing for trial, obviously, for me personally, and probably everybody in here, we prepare appropriately to ask the right types of questions, meaning of my own client, I'm asking open-ended questions, and because sometimes an unrepresented party does show up for the actual trial with a lawyer. So in order for myself to be prepared for any eventuality, I do that. But when trial actually starts happening, for efficiency and clarity to the other party, sometimes those transition into closed-ended questions. And I've had cases where a judge will allow me to continue on in that method, not to take advantage of the unrepresented party, but again, for judicial economy and effectiveness and just procedural efficiency. So I wanted to find out, just from your perspective, what is the judge's role in that, in offering assistance to an unrepresented party, in curtailing those kinds of things when they don't know when and how to object, and then also just the formality of procedure and what you view a judge's role is, because as you said, each judge's courtroom is slightly different, in kind of taking control procedurally of taking that away from us. So where, the other party, we're going to remain at counsel table and the judge is going to ask more questions than I'm going to get allowed to ask. So kind of a two-part question about, what I should be doing, to take that upon myself to make it efficient and effective, and, your role in taking those formalities out of my hands in the courtroom setting.
Okay, so that's okay. I'm going to try to answer both parts, but if I don't, you need to let me know which part I didn't answer. One of the problems I think that we all have is there are certain basic factual things that just you can ask sort of leading questions just to get them out of the way, like have you reconciled the differences cause the remedial breakdown of your marriage? All the child custody, Uniform Child Custody Jurisdiction Act questions. All of those kinds of things. And you live at such and such, you have this bank account. Then what lawyers have a tendency to do is not let their clients actually tell their story. And sometimes, and I learned this from Judge Meisenheimer actually, because I was doing that in a case, and he just basically said, Ms. Tennyson, you need to let your client talk. Oh. So there is a certain amount of that, because what we're trying to do is get a feel for who it is, and if what you're doing is suggesting every answer, what we're deprived deprived of is our ability to make credibility determinations and other things. And that may be your goal, but I don't think it's a worthy one in some respects, because if you have prepared your client, which, you know, you don't apparently always do. If you prepared your client, they're going to be able to answer questions, and they're going to understand kind of what their jobs are and all that kind of stuff. So I would say if it's basic information, this is my philosophy. If it's basic information that is in exhibits or otherwise just sort of fact, like immutable fact, like the address for the house is X, Y, or Z, then ask a leading question, and that's fine with me. If what we're talking about is what happened in an event, then what they need to be able to do is tell their story. And you need to be a guide for that. So sometimes you would hear me say in my court, this is a little too narrative for me. Can you ask another question? Because, you know, sometimes you have clients that just go all over the map, and that doesn't help either. And the same would be true with people who are self-represented, because they absolutely do not understand how to cross-examine, except when they do. And you need to really watch for people who actually can try cases, because they are there, and you don't want to get your clock cleaned by somebody who never went to law school. So be aware of who's on the other side, just as you would if you had a lawyer on the other side of the fence. Does that answer your question?
Yes, it does. Thank you.
And I think if somebody is spoon-fed every answer and you're just walking through it with them, how are we supposed to determine anything about credibility at all? They just come off as coached. I think in trying to sort through when a judge might take control and kind of move along a case, for me, are you taking advantage of the person in a way that's just not, you know, it's not right? I might step in there. On occasion when things drag out, I might say, you know, let's move on to another question or something like that to try to propel the case forward a bit. So
Yeah, you would hear me say something like, I get the point, so let's move on. So,
or I've heard this 5 times.
yeah. Oh, yeah.
Sometimes I do.
See,
say
that was the old me. Now I'm trying to be better about it.
I aspire.
Yeah. Next question.
Okay, so this is a little bit of a selfish question, just because it doesn't apply to law practitioners. But let me just paint a picture for you, because I get this often, and I don't really have quite, I've never really gotten quite great guideline as to what I should do in this instance. So I'm hoping that from both of you, I can get at least your perspectives. Okay, so this is the picture I'm painting. I get a call from, let's say, Judge Loy, and he goes, Jackie, I need a solid. Can you represent the child or children on this particular case? Oh, by the way, self-represented parties, oh, by the way, they're both Spanish speakers. Okay, so Spanish is my first language, so this call is like very intentional. We go to trial. I'm representing the children or the child. But what can I do in order to help? Because we're dealing with interpreters, we're dealing with a whole host of factors, self-represented individuals. What type of assistance do you as judges want from me in order to help streamline the litigation process?
So this is a child's lawyer question.
Yes.
And I'm happy to answer that. And I will just say that I only have 1 minute, so I'm going to say really fast. We want actual evidence.
Okay.
And then the next thing we want you to do is we want you to use your skills and knowledge as it relates to what the law would otherwise order, and assist parties in reaching an agreement before they ever have to come in and testify against each other if we can avoid it. So those are the 2 things we want in reverse order. We want you to try to resolve the case if you can, and if you can't, we need information that is admissible so that we can make decisions.
And I think asking like solid, streamlined, focused questions can also set a good example for the parties who are not represented too. So, but those will never be quick trials.
No.
Thank you very much for your time.
Thank you so much for having us.
We can now, let me finish my introduction of Paul Sosi, or we can have a 15-minute break. You can vote with your feet. See you back at 10:20.
And everybody, as you're milling about and getting some exercise at the break, don't forget to stop by the vendors. They have some amazing giveaways. If you haven't stopped by there are tickets for the November 3rd Trailblazers versus Lakers game, including a $60 credit and voucher for food and other items. There's a $200 gift card. 3 winners for a My Pleading subscription, a Hydro Flask wine set from Truce, and an insulated thermos from Our Family Wizard. So stop by those vendors and give them your support.
He's also got
to the kitchen right now.
Do you have a side preference?
No, I do not. You?
No.
all of my. I can't decide if it's good or not. Also, I forget that I know. Yeah, I didn't know them. I brought like a tiny stack of cards and I got that from here.
We didn't get over here. Yeah, we didn't get over here until late, about 4 o'clock. So.
The stadium, that's right. Much.
Yeah, it's I'm gonna take it too because I'm on the roof.
What? There's an overflow.
Yeah. Oh, you told me there?
April. Look, I'm too.